Hello and welcome to Runkle of the Bailey. My name is Ian Runkle. I'm a Canadian criminal defense and firearms lawyer. Today I want to talk about a case that's a bit of good news with respect to the ongoing legal battles around the AR-15 ban in Canada. Specifically, this is a battle about procedural fairness with respect to Section 74 firearm reference applications. These are what allow you to challenge a lot of decisions that might be made by the Registrar of Firearms or the Chief Firearms Officer. And this case is important because it basically is out there to protect these procedural fairness things, to say, listen, I know you guys made a decision, but we get to challenge that decision meaningfully in court. This is also a really important decision broadly, or really important case broadly, I think, because what we see here is the government trying to use sort of clever terminology to give themselves powers that aren't actually in the legislation. And if this is allowed, it could have implications in terms of immigration issues and all sorts of other aspects. So let's dive in and have a look at this case, and I'll sort of explain the importance as we go. Now, this is out of Ontario, and it's the case of His Majesty the King, which just means the Canadian government, and a bunch of people who I will just sort of describe as badasses, because when you look at it, it is the government had two lawyers there, and these are self-represented individuals. I don't know that any of them have specific legal training, but they went in and they're giving it a really good battle. So let's have a look at what's going on in this case. So reasons for judgment. The respondents received from the Registrar of Firearms letters dated July 20th, 2022, that their firearm registration certificates, due to federal government regulations amended on May 1st, 2020 by an order in council, were nullified and no longer valid. So what happened is they sent out these letters saying, hey, listen, the AR-15 is banned. We think these guns you have are AR-15s or variants, and therefore the registration certificates are nullified. Now, nullified appears nowhere in the enabling legislation. It's not in the Firearms Act. It's not in the regulations. It's not in the criminal code. All of those consistently use the term revoked. So this is important because if a registration certificate is revoked, then you get a Section 74 firearm reference hearing. Whereas if it's nullified, then nothing is specified because, of course, they don't specify anything about nullified because nullified is not a thing anywhere in the legislation. Now, they're trying to actually change this. They're trying to put in an automatic sort of revocation process in Bill C-21, but Bill C-21 isn't law yet. So they're kind of jumping the gun and giving themselves powers that they didn't yet have in law. Yeah, that's kind of the main issue here, or a big issue here. It's really whether they can use the word nullified instead of revoked in order to get around this, which to me sounds like using the word traveling instead of operating a motor vehicle to say that you don't need to be bound by, traffic laws like the need to insure your car. Yeah, okay, so the respondents filed applications in the Ontario Court of Justice for reference hearings pursuant to Section 74 of the Firearms Act. The applicant, the Federal Crown, brings an application to dismiss the Section 74 Firearms Act applications on the grounds that the Ontario Court of Justice lacked jurisdiction to hear these Section 74 applications. So, Ontario Court of Justice, Justice Leach, dealt with the application. On January 6, 2022, Justice Leach made a disclosure order relating to the development and use of a computer algorithm utilized to identify the respondents' firearms affected by the order in council. So basically said, you have to turn this algorithm over. You have to give this information to people so that they can evaluate whether or not that this was used correctly. The Crown subsequently brings two applications. One, a certiorari application involving jurisdiction and error of law issues, and two, a Section 37 application involving a specified public interest issue. Now, a Section 37 application is regarding Section 37 of the Canada Evidence Act, which allows for certain evidence to be suppressed if it's going to be sort of harmful to the country if it's revealed. So that's a second issue here. Now, jurisdiction is kind of the key issue on this one, is does the court have jurisdiction to hear this? and basically means, are you bringing this in front of the right court? So, for instance, if you wanted to bring a lawsuit that is $1 million lawsuit, and you tried to bring this in provincial court here, they would say, we can't hear this. We don't have jurisdiction to hear civil suits where the amounts are that big. And another example of a jurisdiction issue would be, let's say I'm living here in Alberta, and I want to sue another person who's living here in Alberta about facts that took place entirely within Alberta, but I want to sue them in Quebec for some reason. The Quebec court would probably say, listen, we don't have jurisdiction. Go back to Alberta, file the lawsuit there. All right. So let's have a look at the issues that they identify. These are the questions that the court is going to be addressing. So first, did Justice Leach have jurisdiction to proceed with a Section 74 Firearms Act hearing? And accordingly, did Justice Leach have jurisdiction to order disclosure pursuant to Section 75 sub 2 of the Firearms Act? And if not, should certiorari issue? And certiorari here is basically a remedy that says that the lower court made a mistake and instead should have done this other thing, and we're directing that that is what happens. So I'm really kind of broad strokes here, but I'm not going to get into too much about what certiorari is and isn't, because this video would end up being, 4 hours long and people would be sleeping. So we're just going to sort of skip over that and just basically they want the court to say lower court made an oops, and therefore we're going to direct that, it happened a different way. And the next is, should disclosure of computer scripts used in the preparation of the registrar's letters be prohibited pursuant to Section 37 of the Canada Evidence Act? Now, originally I thought I would talk about the law of certiorari. We're going to skip that because it is just getting into the weeds. The main issue here is the question of jurisdiction. So, jurisdiction of Justice Leach to conduct a Section 74 reference hearing. The Crown argues that Justice Leach had no jurisdiction to conduct a Section 74 reference hearing. The Crown argues that the letters sent out by the registrar to the respondents advising that the status of their firearms had been changed by amendments pursuant to a government order in council were informational letters only and not a revocation by the registrar or chief firearms officer as required by paragraph section 74 sub 1 sub a of the Firearms Act. The Crown relies on a number of provincial court decisions. Recent examples include Doherty, Alan Peters, and the Attorney General. So basically, there's been a lot of these cases, and in a number of them, the federal government has been winning. But really, this one I think is going to end up at the Supreme Court of Canada. And at the Supreme Court, I hope that the Supreme Court is going to be asking, listen, where does nullification appear? How does this automatic nullification process happen? Because it's not in the law. They're inventing new terms for this, but it doesn't seem that that's actually in the law. As pointed out in Doherty at paragraph 47, numerous cases in the lower courts, for instance, British Columbia, Saskatchewan, Alberta, Quebec, Newfoundland, Manitoba, and Ontario, have supported the Attorney General of Canada's position that the informational letters, which they put in scare quotes in here, are not a revocation under the Firearms Act, and accordingly, there is no jurisdiction to conduct a Section 74 Firearms Act hearing. Now, if they can just decide that, that they can send out an informational letter instead of following the revocation process, this has real implications for procedural fairness because, at that point, it removes a lot of the opportunities for challenge. And if we think about this in the immigration context, you might be inadmissible to immigrate to Canada if, for instance, you have certain things in your background, or you are considered a public safety risk. Well, they're required to actually deny you, and then you can challenge that. They can't just send you an informational letter saying, because you are ineligible, you don't get to go. This is part of the rule of law. This is part of you get to challenge these decisions in court. This is really important, and it shouldn't be something that they can work around just by picking a new term for it. So in the Queen and Fritz, Justice Guay, or I'm not sure if I'm pronouncing that correctly, also concluded he had no jurisdiction to conduct a Section 74 hearing. However, at paragraph 15, Justice Guay found that the preponderance of judicial thinking was that the provincial court does not have jurisdiction to entertain a Section 74 reference hearing. Justice Guay also indicated that there was another point of view set out in Attorney General of Canada and Stark. Justice Fradsham in Stark, and I have reviewed this in a previous video, concluded after a careful analysis. You can already see where the justice is going here, right? Well, when they describe this as a careful analysis, that the courts did have jurisdiction to conduct Section 74 Firearms Act hearings in the present circumstances. The question confronting the courts ultimately is whether the letters sent out to firearms owners is either 1, informational, or 2, a revocation. Accordingly, it is relevant to examine the exact wording of the letters sent out by the registrar to the respondents. The letters in question, sent out on July 20th, 2020, to thousands of owners, are all basically the same. An example of the letters is found at Volume 2 of the application record involving the respondent BM at tab G, page 360. The letter lists the affected firearm or firearms and indicates these firearms are now classified as prohibited and the previous registration certificates are automatically nullified and therefore no longer valid but should be retained as a historical registration record. And then they go on, and I'm cutting this out, but it basically is a big thing of what your options are in terms of, getting rid of them. You can't use them for hunting except through the amnesty order. Can't be used for sports shooting, etc., etc., etc. I note that the letter is signed off by the Registrar of Firearms. As noted by Justice Fradsham in Stark, there is nothing in the Firearms Act or the relevant orders in council that the respondents' registration certificates are nullified or invalid. See Stark at paragraph 64 and 66. So there's nothing in the law that says that there's an automatic nullification. Normally, the law is where you find the law, but and not just in the mind of the Registrar of Firearms. So Stark at paragraphs 64 and 66, Justice Fradsham concludes that nullification and invalidity must have come about as a result of an act of the Registrar of Firearms. Stark, paragraph 65. Justice Fradsham concludes that nullify and revocation have essentially the same meaning. And, what would the difference be, right? If it's nullified or if it's revoked, in both cases, it means that it's not any good anymore. So that seems to me like a revocation. Accordingly, the registrar, by nullifying and making registration certificates no longer valid, has revoked the registration certificates listed in the July 20th, 2020 letters sent to the respondents. Stark at paragraph 70. The respondents submitted that, in the past, firearm owners were permitted to participate in a grandfathering scheme. As noted in Stark at paragraphs 80 to 86, the Canada Gazette, in its regulatory impact analysis statement, refers to a buyback program and an option for a grandfathering scheme. The letters sent out to the respondents refer to the buyback program, but make no reference to a possible grandfathering scheme. As noted in Stark, in order to take advantage of a grandfathering scheme, the continuous holding of a registration certificate may form part of the requirements outlined in any future grandfathering scheme. Stark at paragraphs 85 through 86. In conclusion, I agree with the careful analysis of Justice Fradsham in Stark and adopt it in its entirety. In conclusion, therefore, I hold that Justice Leach has jurisdiction to entertain a Section 74 Firearms reference hearing. And really, this is what it's about. What does it mean to nullify something? Do they have any process for automatic nullification? Is that set out in the law? No, it's not. And is it the same thing as revoking? Absolutely it is. So and when you think about it in terms, they're saying it's purely informational, but it's not purely informational because they actually had to take steps to identify, is this particular gun an AR-15 or an AR-15 variant? And then once we've decided that that is the case, then we're going to turn around and, nullify, which is revocation, that registration certificate. They're saying it's purely informational, but there's clearly decision-making processes going on there that mean that this is in fact a revocation. All right, let's look at the other issue, which is the disclosure order. So Section 75, Sub 2 of the Firearms Act authorizes the provincial court to hear all relevant evidence brought by the parties. In May and Ferndale Institute, the Supreme Court of Canada held that Stinchcomb principles, that's disclosure. So the government having an obligation to turn over evidence. I should actually do a case on Stinchcombe because it's really super important in the Canadian law context. Apply to criminal proceedings where the innocence of the accused was at stake. The Supreme Court held that Stinchcombe principles do not apply in the administrative context. So that's the same May and Ferndale Institute case in 2005. However, the Supreme Court also held that in the administrative context, procedural fairness generally requires the decision maker to disclose the information he or she relied upon. The respondents in their submissions indicate that in the proceedings before Justice Leach, counsel for the Attorney General indicated that the letters sent out by the registrar were generated as a result of a computer program, loosely referred to as an algorithm, and accordingly, the algorithm used was relevant to the Section 74 Firearms Act reference. It is clear that Justice Leach had the power to order disclosure and did so regarding the algorithm as he determined them to be relevant to Section 74 of the Firearms Act reference. In my opinion, whether relying on the Stinchcombe principles or the May principles, Justice Leach had jurisdiction to order the disclosure requested. Even if an error of law was made, this error would not go to jurisdiction. A disclosure order is not an order of final and conclusive nature. Accordingly, certiorari is not available. Conclusion. In these circumstances, Justice Leach had jurisdiction to conduct a Section 74 Firearms Act reference and had jurisdiction to make disclosure orders. Any arguable errors do not go to jurisdiction and do not justify a certiorari remedy. So the Crown certiorari application is dismissed. So they're going to get to proceed with their Section 74 reference application. That is fantastic news. Of course, this may end up going to the Supreme Court, as I mentioned, in which case it'll be the Supreme Court hearing this whole thing. Issue number 2, Section 37 privilege application brought by Crown. The Crown, in a separate application, seeks to stay or vary Justice Leach's disclosure order on the ground that such disclosure would violate a specified public interest, and that's from the Canada Evidence Act. The Superior Court of Justice has jurisdiction to determine the objection. All right, so the basic principles, and I'm going to skip over a whole bunch of this. Basically, this is a new application where the court is asked to assess whether the protection of a public interest immunity applies to the information at issue. And I'm going to skip over lots of the procedure here because ultimately that would really make for its own video. But let's look at why they're saying that this is a big issue, right? Why is this a critical thing that they're trying to protect? So the Crown at tab 3 of volume 1 of 2 of its application record has filed a certificate prepared by Kelly Paquette, Director General of the RCMP, their Canadian Firearms Program. At paragraph 4 of the certificate, Ms. Paquette indicates that the algorithm, referred to in Justice Leach's order, in fact refers to scripts of a computer code that was created in light of Order in Council's regulations dated May 1st, 2020, that affected the respondents. At paragraph 7, Ms. Paquette indicates that there is no single algorithm as indicated in Justice Leach's order. Rather, the firearms affected by the Order in Council were identified by human actors, who have to, of course, make decisions about revocations, and then several scripts of computer code were developed and executed to implement the Order in Council. Ms. Paquette objects to disclosing the information in the scripts as it would put public safety at risk. So, developed and executed. Now, of course, there's potential for bugs to creep in here, right? You could have an error that gets in that then causes, it to issue one of these letters about something that maybe isn't covered, right? Maybe it's a handgun, maybe it's something else. So Ms. Paquette indicates in the certificate that the specific details of the scripts used to update the Canadian Firearms Information System and databases has no bearing on the action the registrar has taken. I mean, doesn't it though? What if the test is wrong? What if the script doesn't work? What if it contains some very elementary programming error that causes it to go off on things that are not actually captured by the Order in Council? That, I think, would matter. All right. The registrar was not involved in the development or use of these scripts. That was done by a separate unit in a separate directorate from the registrar. So see paragraphs 23 to 24 of the certificate. The gist of the certificate is that the specific details of the scripts, i.e. how it was developed, used, and its interconnection with other CFP databases, presents a threat to public safety. And Ms. Paquette in the certificate asserts at paragraphs 31 to 40 that the disclosure of specific details of the scripts would potentially allow hackers or cyber attackers to access the RCMP information system, which would be injurious to the public interest in 3 ways. So this is basically, you can't use our you can't see that our computer software actually works right, because if we disclose it, then hackers could attack us, which kind of suggests that they think that it might actually contain bugs, that it hasn't been reviewed for that sort of thing. But we should expect to see more and more of these fights happening, because there's going to be more and more use of algorithms, potentially of AI, potentially of all sorts of electronic tools in order to make these kinds of decisions. And shouldn't the basis for that be something that is open to the people who are affected by those decisions? I kind of think so. So the issues that they raise are, first, the information on the CFIS could be manipulated by hackers, which would make it less reliable when accessed by law enforcement. 2, hackers could access and disclose private personal information of millions of firearms owners and hundreds of RCMP employees. And 3, unauthorized hacking could undermine the public's confidence in the RCMP's ability to manage its own system and security. So really what they're saying here is we are relying on security through obscurity. And security through obscurity is not really security at all. If hackers are able to somehow use these scripts to do all of these things, then they're going to do it, whether or not those scripts end up disclosed in this court case or not, because basically any government system is going to be subject to various attacks. Like, it should be assumed that if you're writing a government system, that it's going to be a high, priority target for, people who want to engage in ransomware attacks, just people who think it would be funny, foreign governments, all of these things. Organized crime. Organized crime has plenty of reason to go after this. So I'm really concerned when they say, hey, if we disclose the algorithm, we're going to get hacked, because it means they're just going to get hacked. If you're relying on these things being secret to protect yourself, that doesn't work. We know this. Like, this is, yeah. To establish the encroachment of a specified interest, it is not necessary that disclosure will necessarily endanger the specified interest, only that it might. And so they say, upon reviewing the certificate, I am satisfied that disclosure of the details of the scripts encroach upon a specified public interest. I mean, I agree that the legal test is probably met. I think that the legal test here is going to end up being a little broken as we go forward in the current era. I don't think that this is going to be workable for the government to just constantly say, hackers exist, therefore we can't turn over any of these scripts that we are using to make fundamental decisions affecting people's rights and liberty, because people could go to jail over this stuff, right? So this is, I have problems. All right. Legal test step 2, balancing act between the specified public interest and disclosure. And here we see that the respondents note that they don't actually necessarily want the full details. So the respondent, Mr. Cipriani, submitted that the respondents don't need the specific details of the algorithm. What they want is who created it, when were they created, who was involved, who was consulted, what was the involvement of the registrar. So, and then, once they have who was involved and all of that, they can potentially subpoena these people to get them to answer questions about this stuff. So, another of the respondents submitted that the respondents are not interested in the computer code, but are interested in what the registrar did, and who, what, and why were the parties involved with the preparation, parties involved in the preparation and sending of the revocation letters sent to the respondents. Basically, they indicated that the respondents want disclosure regarding who was behind the algorithm and how it was decided to use the algorithm. So they say, I agree with the Crown's submission that there are no criminal charges to be dealt with and rights to liberty, life, and security are not at stake. Yet, I mean, this is actually setting the foundation for future potential criminal charges. So, however, the respondents have done nothing wrong and are entitled to disclosure pursuant to Section 75, Sub 2 of the Firearms Act and fundamental purposes of due process. So, given all of that, the order is that the Crown is to provide disclosure relevant to the scripts used to identify the respondent's firearms, which is to include who created the scripts, when they were created, who was involved directly or indirectly in writing the scripts, who was consulted, and the involvement of the registrar in creating the scripts and the involvement of the registrar in the preparation and dissemination of the July 20th, 2020 letters the respondents received from the registrar. The disclosure outlined in paragraph 1 above does not include the scripts comprised of computer code as outlined in paragraph 7 of Kelly Paquette's certificate. The specific details of the scripts and computer codes in the scripts are prohibited from disclosure pursuant to Section 37, Sub 6 of the Canada Evidence Act. So we're not going to get to read that over and see, did they actually, did these scripts, are they scripts that we can expect will do what they say is on the tin, right? Because let's say instead of, I dabble with trying to program, and I can say that it's really easy to make all sorts of errors. For instance, it's really easy to say, if we want A and B, to confuse that and make it A or B, which can then end up making your entire script spit out bad information. Or instead of saying it must be A, it's really easy to get that wrong and say must not be A. And then you get the opposite of the information that you wanted. So I would have liked to have seen a little bit more in there. I would have liked, I probably would have asked for the code, but I get why they might have backed away from that. That's a tactical consideration. And honestly, I can't fault the people here because this is a big win. This is a really big win for Canadian gun owners and Canadians generally. I've made the point that if the government can pull this here against gun owners, they will absolutely do so against other people. And so even if you have no sympathy for Canadian gun owners, you should be concerned about this, because if they can start playing these kinds of games, it doesn't stop here. Like, it just never stops where, in one place. Once they have a tactic that works in one, in a sort of context like this, they're going to keep pushing it. They're going to keep trying to extend it, because why wouldn't you? It gets them all sorts of benefits. So this case is, a big win. As I said, I expect that we may well see these questions ultimately being addressed by the Supreme Court of Canada. But it's nice to see a court sort of understanding the issues here, which is basically you can't just invent powers for yourself. And, the government has to be limited by what's actually in the law. Same as I have to follow the law and you have to follow the law. The government also has to follow the law. And that's really all that's being asked for here. Anyway, thank you guys for watching. Thank you guys for sticking with me. I know it's been a while since I've had another video out. COVID really did a number on me and it was unpleasant, but back recording videos, and hopefully you guys enjoy this one. Please like this video, share it with your friends, subscribe to see more content like this. There's not really anywhere else I'm aware of where you can go to see these kinds of analyses of Canadian legal cases. Let me know if there's a case you want me to cover. I think I want to cover Stinchcombe at some point in the near future, because it's a really important one. It is fundamental to Canadian rights. If you're ever charged with an offense, it's a huge decision. It completely changed the landscape here in Canada, and so I want to cover that one. I also want to thank my Patreon supporters at the $50 level, the CCFR and Canada's National Firearms Association. And just give me 1 second here. I'm just wrestling with all of this. At the $30 level, Sights and Arms Limited and Jane Babe and Luxor. And at the $20 level, Mark Haywire, Gerald of the Bailey, Dale Nesbitt, Cameron Johnson, Andrew Elsich, and Vicky. Thank you as well to my $10 supporters who will be in the crawl immediately following. Thank you guys for watching, and I hope this is armed you with knowledge.